In Texas, when I have somebody come into the office with a family violence charge, there's some questions that I always ask. One is, who called the police? Was it a neighbor? Was it the alleged victim? Or did you call the police? That all plays a role in evaluating the case. The other thing I want to know is, were there any visible injuries to the complainant? And the other thing I want to know is, are there any pictures of the complainant? And the other thing, maybe one of the most important things, does the complainant, does the person that allegedly was injured, do they want to prosecute you? And so if someone comes in and they're the ones that called the police, in other words, the person that came into my office that was charged called the police, and there was no visible injuries, and the person wants to drop the charges, well, that's probably the best fact situation you can have in fighting one of these cases. It doesn't mean the state it'll go away, but those are probably the best facts. Now, what I usually do is talk to the client, figure out what's going on, and I tell them I don't want to go in any detail, great detail at this point. I also don't want to talk to the complainant at this point. What I want to do is collect from the state all their evidence, including videos, police reports, statements that were made. I want to look at that before I talk to witnesses, before I talk to the complainant, because I kind of want to see what's going on, how has the story changed. And if the complainant wants to drop the charges, very often I'll ask somebody else to be in the room when I interview the person. In case that person changes their mind or changes their story, I want somebody to be able to back up what was said to me. And so in most cases, is there a strategy? Yes. Does it vary? Yes. But there are some common themes, and that is trying to figure out how strong or weak the case is, and then before we start interviewing and talking to everybody, seeing what evidence the police have.